Good afternoon, President Hente and council members. Kyle Campbell, Interim Director of Planning. I'll be presenting the proposed oil and gas regulations to you this afternoon. I will be going through several of the slides that have been previously presented, and so I will try to keep my presentation as brief as possible. I also wanted to inform the council that as of last week, I have been designated as the local LGD for the City of Colorado Springs, and I'll be acting in that capacity for my tenure at the City of Colorado Springs. The proposal before you today is to move forward with the approval of the City Planning Commission from August 16th of 2012 with the proposed regulations. The proposal is to establish new regulations for oil and gas operations within Chapter 7 of the Colorado Springs City Code. Just a brief background as how we got here as it relates to the involvement of the Oil and Gas Committee findings and how those findings were then moved forward with the proposed regulations. As we have discussed and the groups have discussed, regulation of oil and gas development is primarily a state function through the Colorado Oil and Gas Conservation Commission. The city can impose reasonable land use regulations that are not in conflict with and which can be harmonized with state oil and gas regulations. Thirdly, requirements for building permits, access road maintenance, emergency response, and fire protection plans and distances that buildings must be set back from existing wells have been upheld as matters that the municipality may legitimately regulate under its land use authority. And lastly, local regulations addressing noise abatement, visual impacts, and setbacks more stringently than the state have been struck down in other municipalities around the state. Continuing with the background, City Council has previously acknowledged the work of the Oil and Gas Committee and all the hours and the efforts and the outcome of that particular committee moving forward with the regulations being considered today. City Council then requested that city staff prepare draft regulations and bring them to the Planning Commission for public hearing. Planning Commission took that step and that responsibility very seriously, moving forward with a general briefing that took place on July 12th, work sessions on August 2nd and the 9th, and then the public hearing on August 16th, in which recommending approval for those regulations. Major considerations as we move forward with this discussion: avoid operational conflicts. That's been a large topic of conversation, essentially avoiding the conflicts between municipal ordinances and the areas of law established by the state or the federal government. And so the issue of avoidance of operational conflict has been acknowledged in the regulations that are being proposed right up front in the description of the regulations. Operators' early engagement with the city. As the LGD, we are also proposing that as early as possible that the entities looking at embarking on oil and gas drilling approach the city. The LGD would be the sole contact for that responsibility as currently being proposed. And as we continue to move forward and look for guidance from City Council and also working with city staff as we further define the LGD role, we want to make sure that there's no confusion as far as who that main contact should be for the city. The LGD would then rely upon the geographic land use review planning staff to help augment the efforts moving forward, but trying to keep essentially as that liaison between the entities requesting the permit, the COGCC, and all the other entities, keeping that solely and squarely with the LGD as a responsibility. Limited potential for location in developed residential areas. Prior mapping, and I can certainly pull that up at a later time if we need to, clearly showed that with looking at the areas east of I-25, looking at those particular areas or parcels that would be large enough to be able to accommodate the initial exploration requirements of approximately 10 acres and then ultimately the reduced area of approximately 4 acres for drilling operations was very, very limited within the City of Colorado Springs, with the exception, obviously, of the Banning Lewis Ranch area. Development standards and water sampling rules we'll be discussing at a later time in this presentation. We'll move forward with a little bit more detail and conversation on those two matters. And then as it relates to inspections that was brought up, The draft regulations being considered does include definition of what the inspection capability would be. There is also language that has been included as it relates to authorizing the city to enter the properties in order to do inspections, and we feel that with the regulations being proposed, it's left enough flexibility to be able to define and create that inspection process as this program moves forward. Obviously, not knowing if there will only be 2 wells or there might be 200 wells or some other number, it's hard to create a thorough inspection system until we further understand what the fiscal requirements would be in order to support that inspection. And then this allows, with the regulations that have been proposed, the ability to essentially create and like I said, create that program as the need requires moving forward.
Kyle, Councilmember Snyder has a question.
Yes, would that, okay, just a minute, the gears are spinning. The inspections, would that be incorporated into the IGA? The process for those inspections?
It could be. It could also be entered into with a memorandum of understanding. So there are some different avenues as it relates to how we could incorporate, those inspection criteria moving forward. As we're looking at it right now, it would be more of a code inspection more than anything else to make sure that the requirements that were set forth on the development plans are being adhered to. So that's primarily what we're looking at it at this particular stage, is to have it go through a code enforcement process as already defined by city code to move forward with.
Is that what we talked about last time with council, that the inspection was going to be an inspection of the code or inspection of gas and oil? That's news to me, that the inspections were meant to inspect about the code. Is that new?
The prior conversations that I've heard the planning department have with council did indicate that there was if there was a desire to have city inspectors, that it would require some type of IGA with the COGCC. I have heard planning indicate that before. And it's not really appropriate to put it into the ordinance because it's going to be a separate agreement with that state agency.
No, my question was about the IGA. Would that be something that we would put in the IGA about the inspections and how we conduct them and the process and things like that?
Yes, that would all be discussed.
Go ahead, Kyle.
As far as the ordinance organization that's for your consideration today, there's the administrative sections, section 7.5.1701, the purpose, authority, and applicability. This gets into several of the sections, including definitions that have been provided of the various components of the regulations. Permitted uses, the tables that are being proposed are showing that these oil and gas drilling operations would be permitted uses within all zoning districts. And then the requirement for building permits for all of the facilities that would be constructed as a part of the drilling operations. Application and review procedures. As stated earlier, the pre-application meeting is a requirement of this. And once again, we are stating that the earlier that can take place and most appropriately and preferably prior to filing of the state application, that will allow the city the opportunity to review what is being proposed, the proximity to existing land uses or future land uses, and provide feedback as early on in the process as possible in order to identify any potential conflicts for existing or proposed uses moving forward. The application requirements are also included, including the general development application, the requirements of a vicinity map showing the clearances from structures and from other adjacent land uses, essentially the 1,000-foot setback that has been discussed, and then the oil and gas site development plan showing access to roadways, showing the configuration of the facility, and once again showing its relationship to surrounding properties, including easements within a 400-foot radius and any other items, including environmental issues, streams, creeks, drainage ways that might be needed to be considered as a part of the application permit moving forward. The application review. The administrative review of applications located in low density areas. The definition, as discussed at informal, for high density areas is anything that has a greater density than 2-acre lots moving forward. And so based upon this, the administrative review would only be considered for those drilling locations that are more than 1,000 feet away from any adjacent use, building, or structure as identified in the definitions. Planning Commission would then be the review authority as proposed for anything less than 1,000 feet or in relationship to those higher density areas. Development standards. The development standards being proposed are limited to those areas within the city's purview. Other standards, the air, water, noise, and lighting, are subject to COG/CC rules. As an example, and we'll talk about it here in a little bit, as far as water, which has been a point of discussion, there are different avenues in order to address water quality. Some of that is, one of those opportunities is an IGA with the COG/CC. Another would be an MOU with the actual entity that's applying for the permit. Both of those have been used successfully in other parts of the states, both with the private entities and with the municipalities, and so those are options that we have moving forward in order to address and further define some of those items that there has been prior discussion on. Code provisions. One of the larger ones is as it relates to traffic impact mitigation. There is a requirement with the submittal for a drilling permit to provide a traffic report that identifies the impacts to the adjacent roadways. It would need to identify the traffic volume being proposed to be coming from the drilling site, and then analyze from a financial standpoint what the impacts would then be on the adjacent roadway networks. It would also identify if there's any improvements that would be required on the adjacent roadway networks as it relates to turn lanes or any other widening improvements in order to accommodate the proposed permit use. And then financial assurances would then also be required in order to guarantee that the road system, as it was found, would be returned to that original state after the operation of the drilling function to make sure that any degradation that takes place is addressed by the permit holder. An emergency response plan is also required that addresses fire protection, also addresses the nearest medical facilities in case there are accidents that would take place, and so that would all be defined within the emergency response plan. The review criteria being considered is that it would comply with applicable code requirements, that the proposed permit location would not conflict with master plan roadways, schools, and park locations. And that would be one of the key items that would be examined as a part of that pre-application process to better identify and work with the permit applicant to let them know if there are any immediately identifiable conflicts with the proposed location. No conflict with existing or planned utilities. Complies with engineering and drainage manuals. So any street improvements required, any grading operations that would take place would all be under the auspices of the engineering and drainage manuals that already exist. Does not overburden existing public facilities, whether that be roadways or other utilities, would also be addressed. Does not create undue traffic congestion. The financial assurances, once again, obtained for road and bridge impacts, and not otherwise detrimental to public health, safety, and welfare. Part of the permit administration and enforcement, the right-of-way entry to inspect for conditions of approval and abatement of violations, and establishes authority for the city to enter into agreements with state and federal entities to inspect for and report violations of state and federal requirements. And so verbiage related to that has also been included in the regulations. Water sampling rules. As previously stated, there are different ways to approach this. One of which is the IGA with the COG/CC moving forward. The other would be similar to what El Paso County is doing, or an MOU with the actual operator. And so because both of these avenues have been successfully used in other locations of the state, we feel like that with what's being proposed, we've got that flexibility moving forward to either continue along the avenue that the county is looking at with the IGA, or look at it on a case-by-case basis. Once again, not knowing the full quantity of permits that might be submitted, we could take some time to better evaluate, see how many pre-application meetings are scheduled in order to see if maybe it is more efficient to handle it with an MOU on a case-by-case basis, or we could immediately dive into a discussion with moving forward with an IGA. In summary, the effectiveness of these regulations depends on a number of things. One, as previously stated, the early operator engagement with the city. Can't stress that enough. Moving forward, with that LGD role being further expanded and the scope being defined, with the newly created local government liaison position that was just implemented in August, there is now an intermediary between the LGD and the state that allows an additional resource for the LGDs to work with that LGL in order to better understand the process and to help navigate the approval process. It's important that the operator's application is crafted in consideration of the city issues and concerns. So through that pre-application process, there will likely be a number of issues that might be raised as it relates to proximity, as it relates to access. And so obviously the effectiveness will depend upon those applicants then coming back with an application that addresses those items that were identified in the pre-application process. Planning Commission review of applications in high-density areas, as previously discussed. Reliance upon state and federal rules in areas of potential operational conflicts. LGD's ability to secure additional conditions of approval on state permits. And the LGD also has a number of other avenues available to that position as it moves forward. One, the LGD can ask for some additional time, for more time for public review. The LGD can require a hearing by the COGCC if an item gets either too complicated or controversial. The LGD can also request state health department involvement depending upon the particulars of the proposed permit application. So the LGD has a number of tools at their disposal in order to, one, to help be that liaison between the permit applicant and the city and the state. And so those are just some of those items that the LGD has at their disposal. And then once again, use of agreements to achieve the higher standards, whether it be the IGA or the MOU on an individual application basis. The Planning Commission recommendations, they did recommend approval. They deleted 2 of the definitions that were previously discussed. And then there was an addition of a new section authorizing appeals of oil and gas permitting decisions in accordance with the standard city practice as far as how that protocol would then work after, say, a planning commission approval or after administrative approval as far as following normal city protocol as far as what that appeal process looks like.